the 15th episode of the 39A podcast. This is Adrija Ghosh from Project 39A, an organization that conducts interdisciplinary research on a range of issues dealing with the criminal justice system. In today's episode, we are in conversation with Lubhyati Rangarajan, who is a lawyer and the editor databases of the Decade of Darkness, Article 14's Sedition Database Project, which has made data on all cases registered over the last decade under Section 124A of the Indian Penal Code publicly available. This is the first independent database to track and analyze the use of Section 124A dealing with the offense of sedition. Sedition is defined as speech that brings into hatred or contempt or excites disaffection against the government and is punishable with imprisonment up to 3 years to a life term and fine. Article 14's database shows that more than 800 sedition cases were filed against 13,000 Indians since 2010. These include politically motivated cases, as well as cases against ordinary people for everyday activities. Of the 126 people for whom trials have concluded, 98 were acquitted of all charges, 13 were acquitted of only the charge of sedition, and 13 were convicted, rendering the conviction rate as low as 0.1%. Thank you so much, Lubhyati, for joining us today.
Thank you so much for having me.
To start, could you please give our listeners a brief overview of what transpired at the Supreme Court before the interim directions were issued on 11th of May?
What happened on the 11th of May was that the Supreme Court, in an order, in a batch of writ petitions that were filed challenging the constitutionality of sedition, said a number of things. One, it said that it hopes and expects that the central and state government will refrain from registering FIRs invoking sedition charges. It also said that all pending sedition trials, charges, investigation, that is into charges framed, would also be kept in abeyance. This assumes that this is at the sort of charge framing stage onwards, that these proceedings would be now kept in abeyance because, and this is where things are a little complicated, the center filed an affidavit saying they would reconsider, review the law on sedition. And the center said this in light of the fact that the Prime Minister believes that because we're celebrating Azadi Ka Amrit Mahotsav, which is 75 years of independence, it is time for us to shed colonial baggage. And the center also said that, therefore, it is time to reconsider the law on sedition. So this is really what transpired at the court. And it remains to be seen, really, what happens in the next date of hearing, which is the third week of July. But what appears to be the case at the moment is that the language of the court also is interesting here, where they say they hope and expect that the government won't register FIRs. And even if they do that, then the aggrieved parties can approach the court for relief. But what's interesting, as I said, is the language, and they did not direct or order the government not to register FIRs. They merely hoped and expected. So that was a little bit discouraging.
Could you give us a sense of what was the government's initial position and how their affidavit was slightly different from what they took as an initial position before the court in the hearings?
So the week starting 5th of May has been interesting. I mean, there were multiple adjournments before that. The Solicitor General sought time to file affidavits on other dates of listing. But what happened after the 5th of May was the Attorney General submitted that Kedarnath Singh is good law, that sedition doesn't need to go. The Solicitor General also in his written submission said that, almost the same thing. But that if the matter were to be decided, it should be referred to a larger bench. The petitioners, in the meanwhile, the lead petitioner in the case initially argued that the matter not be referred to a larger bench because legally that was not required. But the manner in which perhaps the government responded also caused the petitioners to argue that, this is something they are prepared for final arguments, and we can certainly argue on the referral point should this matter be referred to to a seven judge bench. But on the 9th of May, the Solicitor General placed an affidavit by the Ministry of Home Affairs, which said essentially that the center was now reconsidering or reviewing the law. However, there were many unanswered questions in that affidavit, such as what is the forum before which they will reconsider? What is the process of this reconsideration? Are they going to solicit views from the public? How much time will it take for this reconsideration? None of these questions were answered in the affidavit, nor did the Supreme Court ask this of the Solicitor General in court. So it's sort of, it's a bit like reading between the lines. This entire week has really been all of us trying to read between the lines. And I think the understanding now is that the court has accepted that this is an executive mandate to reconsider sedition. Instead of saying, all right, we will argue on the point of a seven judge bench referral and then decide whether we're going to proceed with final hearing. Instead, it has now deferred to the executive and said, all right, since the executive wants to reconsider the law, we will give it that time. And this is what has been actually quite disappointing. When you have extremely solid grounds on which sedition can be argued, ultimately, if it is set aside by the court or not is again a matter for the court to decide. But we could have at least argued that sedition should go, that it doesn't deserve to be there in this democracy anymore. And this is what is ultimately this week has been discouraging on that count, that the court had an opportunity to review this review this law, and instead it deferred to some sort of executive desire to review the law. Again, extremely vague affidavit. No explanations were provided by the government on what that means. So it sort of, to be honest, leaves us all hanging in the balance.
And as you expressed concerns about the impact of the interim directions, because the language is so vague, there's been a lot of debate as to whether the court has taken a stance or whether it hasn't. And in your view, you'd say that it's still to be seen what the actual effect is. So, would you say there is a chance that it's not properly implemented and it goes the way that things have gone with Section 66A of the IT Act, which has been invoked even after being struck down by the Supreme Court?
Yes, I mean, you're absolutely right. One of the problems we always see with Supreme Court judgments, historically, has been its implementation. And 66A is a great example of that the provision was struck down entirely as being unconstitutional. And there were still FIRs being filed despite that. I mean, here we're talking about an interim sort of measure by the court saying, they hope that no new FIRs will be registered and that all pending sedition trials will also be kept in abeyance. Now, this order will have to be communicated not just to police stations, but also to district courts, to magistrates, to high courts. This is also something of monumental proportion, just the element of having to communicate this to every one of these bodies. The next date of hearing is July, so one would hope that the order is communicated immediately to state governments, to police departments, to high courts, to lower courts. And this is on the center. The onus is on the central government to do this. Now, again, this is where orders like this are also difficult to understand, especially when the language of the court that's used is also confusing, the hope and expect language. So again, it seems like the burden will be on the petitioners or the accused to once again approach court if something happens, which is, again, it's unfair, but it is to be expected.
Right. And coming back to again what happened before the court, it seems that all parties before the Supreme Court have sort of agreed that the law is being widely misused. Even the center originally adopted the position that the law is being misused and it can be fixed through guidelines. But that the misuse in itself is not a ground for constitutional challenge. Could you give us a sense of how you think the law is being misused based on what you've encountered during your empirical and investigative research on sedition? And also whether you think any guidelines can solve the problem?
I mean, yeah, there's a lot to unpack in that question. One is, of course, the term misuse of sedition, which I have personally been thinking about, which is that it assumes then that there is a correct way to use sedition. But leaving that aside for a moment, I mean, if we talk about how sedition has been used, and this is what our work at Article 14 has demonstrated. But a few instances of this use, for example, in one case in Karnataka, this was in the aftermath of the Pulwama attacks in 2019, and there were 6 people who were arrested on sedition charges for liking a Facebook post that said, "I stand with the Pakistan army." Now, originally we got the bail orders from the eCourts website. All 6 orders are actually identical in their content, barring the cause title, which is the names of the accused. So we sort of also assume that these are people, perhaps they were on the same WhatsApp group or the same Facebook group, and they were sort of together when they clicked that post. And it's only when our investigating reporter went to the field that he found out that there were actually 6 different people in 6 different districts who were then picked up by the police for liking this post. Now, there are many things going on here. One, who are these accused? One of them was actually a shepherd. One of them was a chicken shop owner. One of them owned a pan and beedi stall. What was common among all of them also was that they were all digitally illiterate. They did not, they did not understand what they were clicking on. They thought it was actually supporting the Indian Army. They didn't realize it wasn't supporting the Indian Army. And we're not getting into, of course, whether who you support is also now considered seditious, of course. But there are, a lot of things sort of happened after they clicked the post. One is also that the police came in about half an hour later after clicking the post, because again, these are all men who in their own districts or in their own villages are also on village WhatsApp groups. And so screenshots were taken of their Facebook posts and sort of traveled and found their way into the police station's, mobile phone, I suppose. Now, it's stories like this that sort of make you wonder whether sedition, whether a shepherd who studied up to third standard, who just happened to like something on Facebook, is really overthrowing the government. And this is just one instance in a long line of instances. And in fact, Uttar Pradesh and Karnataka have the highest number of sedition cases based on social media posts, all of which involve people who are, rural, first time social media users who use, these apps that have been installed on their phone by their local mobile shop owner, who are also on local village WhatsApp groups where, there may be sort of hyper local political functionaries on those groups. So there's a lot of hyper local politics that dictates whether or not a sedition case is also filed. And this only contributes to the idea that yes, sedition is being misused, that there are no checks, there are no guidelines on the police. And to the second part of your question, which is, can there ever be guidelines to regulate the use of sedition? I don't believe there can be guidelines to regulate sedition, primarily because of the evidence we've discovered, again, through our investigative reporting. For example, again, in UP, there was, a 36-year-old Muslim electrician, and again, here the religion is important, who again happened to like or share or click on a post that allegedly insulted the chief minister of Uttar Pradesh. What then happened was that he was immediately taken to the police station. Activists of the Hindu Yuva Vahini were outside the police station. One of the activists sat with the police officer and dictated the charges that were to be put in the FIR, which included sedition. Later on, the police did drop the section because they felt that it may not be the right section. However, Firoz, who was the electrician in question, continued to be in prison on other charges as well. You know, these sorts of stories that you hear from the ground only contribute to the idea that the law, which is 124A here, cannot be excluded from the real politic, certainly not in our present climate. This is something, of course, that may be hard to convey before the judiciary. But the truth is that, and as our data tells you, for example, that there's been an annual 28% increase in the number of sedition cases filed since 2014, which is since the BJP came into power. I mean, these sorts of numbers or this kind of rise is hard to ignore when you correlate it with who is ultimately in power, which political party is in power. And so any discussion around sedition is certainly around, say, a court-led guideline or even an executive-led guideline. It misses the point, which is that you cannot, you cannot use sedition in a politically neutral or non-partisan way, simply because the language of the law is worded such that if you are quote unquote disloyal to government established by law, you can be arrested and charged and imprisoned for being seditious. So, to kind of tiptoe around the fact that there can be guidelines that are neutral, there can be checks. For example, earlier this week, the Solicitor General brought up the fact that a superintendent of police could be the acting authority. Now, the police is also part of the executive. To imagine that a police, and again, our data also tells you that the rise in the number of Hindu right-wing groups that file cases or that pressure the police to file cases is also has also seen a spike after 2014. So, I mean, to imagine that there can be a neutral arbiter who decides whether or not an FIR can be filed in a case of sedition that directly threatens the government established by law, I think is quite far-fetched.
To go back to what you mentioned, that you're not really sure if sedition can ever be legitimately or correctly used in a constitutional democracy, and what you said about how it can easily be molded and used for political purposes, and with changes in political power, anyone can use it in any manner that they want to. Why do you think that sedition can never be legitimately used? And second, then, is this vagueness of the law and overbreadth of the law one of the constitutional grounds that you think that the law should be challenged on?
I'll also you mentioned being used for political reasons, but I'll also point out one more thing before I answer your other questions, which is that in our work we found a lot of cases that we categorized as everyday. Now, these were cases that were not filed against people who criticized or dissented or who were, say, in the opposition. These were cases filed against people for doing ordinary things or living their ordinary lives. For example, in one case for wearing a T-shirt that had the words Pakistan Cricket Board inscribed on it. In another case, there were 7 boys, and I say boys because some of them were juveniles, who were arrested for dancing to a song whose lyrics were apparently objectionable or considered seditious. Um, there was another case in which we found that the trigger for the sedition case was actually a loud bike silencer, which sort of snowballed into a clash between two groups, and a sedition case was filed against one of the people in that group. All of these instances also tell you that, of course, now the fact that it's being weaponized in a certain way by those in power, at the center and the state level, is one thing. But it's also important for us now to understand, given what we know, is that sedition is used not just against dissenters or critics, which is also the sort of prototype of who we consider seditious or who has been considered seditious. We're also seeing a whole range of cases in which, none of these elements are in place, which is what also makes the law that much scarier and that much harder to sort of define and limit or understand actually what is sedition and what isn't. Which then brings me to the point of vagueness. And certainly, yes, and this is something, we the court in, say, Shreya Singhal used that as one of the grounds to strike down 66A, the same ground of vagueness, overbroad, arbitrary, subject to, misuse by the police. Sedition is, in fact, no different, except, of course, that it's graver. It carries a social stigma that we have also encountered in our stories, that it is reported as Deshdroh. In many languages, it is translated into Deshdroh. And so the tag of being a Deshdrohi or a traitor is one that is extremely, extremely hard to shake off for the accused. So, all of this sort of put together, it only tells you that fundamentally sedition is simply not compatible with a democracy, because sedition implies that you are a traitor, you can be a traitor. And there can't be traitors in a democracy, because a democracy is for the people, by the people. So, it's impossible then to sort of define the limits of sedition, have guidelines around sedition, because fundamentally then you sort of it implies that you agree that there can be traitors in a democracy. You agree that the government can be overthrown by an attempt to incite disaffection. Again, none of these terms are defined. And we know now that Kedarnath Singh tried to limit the scope of sedition by saying incitement to violence, is the standard. But again, this test was laid down in 1962. We're none the wiser, 50, 60 years later. And in fact, as our data shows, so many of these cases don't involve violence. They don't even involve criticism. They don't even involve protesting. There is no excitement of disaffection. In so many of these cases, they're just ordinary, for instance, social media users who don't know what they're clicking. And the fact that you can even file an FIR against them is just very, very telling of executive behavior, of police power, of the realities of hyperlocal politics on the ground.
Right, and you talk about the social stigma attached to a charge of sedition, and in relation to that, I'd also like us to talk about how the process is the punishment. We all know that sedition cases do not end in conviction, as in there's a really low conviction rate. So, could you just tell us a little about what it means to say that the process is the punishment?
Yes, I mean that is again a very, very important facet of what happens after a sedition case is filed, because we've spoken of how sedition cases are triggered today or since 2014, and that backstory is also important. But what's also very important for us to understand is that after the sedition case is filed, one, of course, there is the social stigma. Two, we interviewed about 60 people who were accused of sedition in Uttar Pradesh, Karnataka, and Assam. Almost unanimously, each of these accused were from a rural background, a lower middle class background. Each of them has been and continues to be in debt to pay legal fees, to pay, bail bonds, also the sort of other day-to-day expenses that come up when you are implicated in a criminal case. That is, you have to travel from your village to the district headquarters. Again, for so many people, this is an entire day's work. So many of them are either daily wage laborers or small time business owners, and so they cannot afford to sort of travel to court, to the police station to report, for investigation or for other reasons. So the criminal justice system also puts in place all of these measures that are frankly very oppressive to people who don't even have the means to afford a lawyer. Um, this is, of course, part of the reason why they process the punishment. In addition, of course, while they're in prison, and they may be in prison, we found out from our sort of empirical work that you could be in prison for at least 50 days until the trial court grants you bail, and 200 days until the high court grants you bail. And all this sometimes for a very innocuous social media post that you did not even know you were clicking. So not only have you been in prison for at least 3 months or 4 months or 1 year, in the meantime you've lost your job. You may have been the sole breadwinner of your family. You might have sick parents or sick family member to look after. So there are those hospitalization bills. Many of them come out and find that they are struggling with mental or physical trauma themselves because of the impact of the case. And then there is, of course, this, the fact that the case will now drag on because there is no sort of, the interest in the trial is far less than the interest in filing the FIR. So you'll see a lot of media frenzy around the registration of an FIR. But by the time it comes to the stage of actually prosecuting someone for sedition, this is where the slowness of the system is very evident. So we see a great deal of speed at the registration of FIR stage, at the arrest stage, and and in keeping them in prison for a few months to a year. After they're released on bail, the case sort of slows down. The interest goes away, but not for the accused. The accused still has to report to the police station. They have to pay bail bond. They have to pay their lawyer. They have to, therefore, to do all of this. Almost everyone we spoke to has sold land, livestock, jewelry, taken on debt from moneylenders at exorbitant interest rates. In one case, there was a daily wage laborer who we could not speak to, even though we went to his house to interview him, but he was out for the day, and so we couldn't speak to him. But we did find out that the fact that you are a daily wage laborer means that each time you go away for one day, you lose a day's wages. So all of this sort of adds to that feeling for the accused and their family that the process is ultimately the punishment. And so also mapping the socioeconomic profile of the person accused was very important for us to find out what the impact of sedition really is on the ground.
And to get appropriate relief, as the court said in its interim measure, is if fresh cases are registered, these ordinary people will still have to bear the costs and the trauma of finding a lawyer, paying that lawyer, and seeking that appropriate relief.
Exactly. I mean, again, the burden is on the accused to go to court and say, look, an FIR was filed against me. Why should it be the burden on the accused to do that? And as you said, how many people can afford that lawyer? If you're filing sedition cases against people from, with barely any income to survive, how do you expect them to find a lawyer to challenge these sorts of, to challenge an FIR filed against them, let alone bail, let alone having to fight for bail? So, I think the order of the court, and perhaps in hindsight it might occur to many of us, is very distant from the realities of how sedition actually plays out. It ignores so much of what's going on, that we sort of now discovered as well, through our research at Article 14. So many of these realities are ignored. How impossible and complicated it is actually to ensure that that particular police officer in that thana, in that village or that district in Uttar Pradesh, is has to apply their mind to whether or not this was a seditious case. So ultimately, it is in the hands of the police. It is in the hands of the executive to ensure this doesn't happen. But I think only time will tell us whether they abide by that expectation that's been placed on them by the court.
Now, to circle back to what happened at the Supreme Court, I just like to know your opinion on whether you think there is any added benefit to the Supreme Court striking down the law instead of the central government reconsidering it and then starting to put in motion a process to repeal the law through the legislature or dilute the law through guidelines.
Yes, I mean, fundamentally, the normative considerations are going to be very different. Judicial considerations to strike down a law versus the executive reconsidering or reviewing a particular law, I think stand on normatively different grounds. And unfortunately, we will know perhaps in July, but you know, we we don't have a sense now of whether this will be a Supreme Court led decision to review the law or whether this will ultimately be an executive led decision. Um, as far as the Supreme Court striking down the law, or Supreme Court hearing arguments, certainly because the arguments put forth by 8 petitioners stand on very solid constitutional grounds. Each of the petitioners has relied on a different set of normative considerations, and this is the job of the court to hear both sides of the argument and then decide whether it makes sense to retain or strike down sedition. So it would have been good, or perhaps it will be good for us, for the court to judicially review this law, as opposed to now the government saying that they will reconsider the law. Again, the affidavit of the government certainly doesn't inspire much confidence for me personally, because, as I said, we don't know what this reconsideration means. Are you going to hold public consultations? Are you going to invite papers? Are you going to solicit views? How long are you going to take? Is it 1 year? Is it 2 years? Is it 10? We don't know. Also, the fact that in the affidavit, the normative consideration seems to be to shed colonial baggage in light of the Prime Minister who believes that we are celebrating Azadi Ka Amrit Mahotsav. One would have hoped that there are other more solid grounds that the government could have invoked to say that it's time to get rid of sedition, if at all they believe that we need to get rid of sedition. So, to answer your question, fundamentally, yes, both institutions will decide it within a specific normative framework. And between the two, I would certainly prefer the Supreme Court deliberate than the executive deliberate. Because at the Supreme Court, the petitioners and the respondents will be forced to argue their case on established constitutional principles, on the basis of academic research, empirical evidence. Whereas with the executive, we just don't know what that looks like. It's the affidavit was opaque at best.
Right. And I was wondering if sedition were to go, we still have provisions under the UAPA, even in the IPC, offences against public tranquility, etc., which are equally vague, equally overbroad, and UAPA perhaps more draconian. What do you think would be the effect of sedition being struck down or being repealed on these laws?
So, one is that, of course, if sedition is struck down by the court or by parliament, um, if the reasons for striking it down are solid and again based on constitutional considerations, it's certainly precedent. It is precedent for upholding fundamental rights and constitutional values. However, as you're right that the fact that we continue to have other laws, and in fact, even in the sedition cases that we've documented, it's not only 124A that's invoked in the FIR. It is typically invoked with other offenses in the IPC. So 153A, 295A, 153B, 5052, UAPA, the IT Act, the Prevention of Damage to Public Property Act. I mean, there are so many laws that are invoked along with sedition. Now, so sedition being repealed, while that is certainly good precedent, would not mean that these cases against those particular accused would be dropped automatically, because the other charges would stand, the other charges would hold, and so the case against them could very well proceed. And especially with laws like UAPA, which are far more draconian, far more restrictive, more dangerous in its application. You could be in prison far longer under UAPA. Yes, it's a matter to be concerned about, and that we shouldn't quite celebrate the fact that we have an interim order now. I mean, we still have a long way to go before we even know what's going to happen with sedition. But even if sedition is struck down, I don't think our worries are far from over. There are other laws, as you said, equally vague. For example, offending the sentiments of a community, spreading malicious rumors, outraging sentiments. All of these employ the same sort of broad, vague, unclear definition, which continues to make it easy to be, for anyone really to be arrested for a retweet, liking, a photo, uploading a WhatsApp status, all of which we've seen in sedition anyway. But of course, that being said, sedition going away also means, very importantly, that the tag of being a traitor, the idea that you can have traitors in a democracy, also goes away. So, we should certainly be cognizant of that ideal.
And would you say to curb the misuse of these other provisions, or at least have strict standards on the basis of which they are used, it's so much more important for the court to strike it down by reiterating and emphasizing constitutional standards?
Is it more important for the court to do it, or is it more important for parliament to do it? I think is really a question of how that process, what sort of views are placed before either of those institutions. Because these are the two institutions that can strike down sedition, that can set it aside or repeal it. So, I wouldn't commit to should the court do it or should parliament do it, because both are deliberative processes. Both have to solicit views. Both have to be debated and argued. That is, both institutions require that deliberation and argument, placing, research before it. So, either institution doing it on any of these constitutional grounds, any of the sort of things we've discussed, keeping in mind that there are certain ground realities, there's a certain political climate we live in that makes it hard to ignore how sedition cases are operationalized. So how sedition is filed against people. So I think either institution could take responsibility for this and say that, look, there's no place for this law in our democracy. And yes, it's important. The grounds on which they decide to repeal it is certainly important, but it's hard to predict, right, what that will be. For those of us who who are invested in the issue, I think all we can do is put out, put this out in an intellectually rigorous way to demonstrate why sedition has no place here today. And you can only hope that either the court or parliament listens to all of these views and then decides what they're going to do with it. But it's again something we'd have to, I suppose, wait and see what this process looks like, on what grounds these deliberations are made, the kinds of arguments that are placed before the court or before parliament. It's also interesting the timing of the next hearing, which is before the court, which is the third week of July, is also around the time of the monsoon session of parliament. So I don't know. We'll have to see really what happens then. Um, it also, we also have to be cognizant of the fact that the Chief Justice of India is retiring in August. So it seems unlikely, certainly to me, that there might be a referral to a larger bench in that time frame. So I think, this is sort of reading the tea leaves as best as you can, given how events have transpired. But at the moment, I would say, sadly, I am not particularly encouraged by what transpired in court in the last week.
Thank you so much, Lobhyati, for such a wonderful overview of the events of the past week and for sharing your thoughts with us and for also giving us a glimpse into the everyday workings of sedition. I think we all need to remember that when we're thinking about the challenge and what should happen to this law.
Thank you so much for having me. This was wonderful. Thank you.